Amber Heard's legal team is keeping up the fight to get the verdict in the defamation trial against her ex-husband, Johnny Depp, overturned. New court filings reveal Heard's attorneys are arguing that the verdict is not supported by the evidence. And they're also making a shocking claim that one of the jurors wasn't who he claimed to be and is actually 25 years younger than stated in the record. Heard's attorneys want the court to investigate improper jury service. Here's a look at that court document. Juror number 15 had a birth year of 1945. Juror 15, however, was clearly born later than 1945. Publicly available information demonstrates that he appears to have been born in 1970. This filing went on to say, here, the facts show that Juror 15 was decades younger than the individual on the jury panel list, raising questions as to whether they were the same or different people. I want to talk about this for sure with now my guests who are on the show today. Law professor at the University of Georgia and former prosecutor Melissa Redmond in Atlanta, criminal defense attorney Eric Perrier in Davenport, Iowa, and psychiatrist Dr. Guyana De Silva in Yorba Linda, California. Thank you all for talking about this one. It's the case that doesn't seem to ever go away. Let me start with you, Eric, because I have so many questions about what this could mean. A juror that potentially is different from what is on the summons. What do you make just on the face of this argument by Amber Heard's team?
Well, it is a very unusual situation. Normally, we don't hear these kind of things raised, especially after trial. It is surprising. What effect it'll have upon the verdict, that's yet to be determined. On one hand, it's possible this juror really is someone else, but it's someone else and the mistake is an innocent one that would have no material effect on the case. For example, one person who has the same name in a family, but the child of the person who was summoned, and there was some mix-up in that way. And there was no malice, no intent to send the wrong person to court. On the other hand, we could have a situation where that juror is someone who is in fact an entirely different person who appeared in place of the person who was supposed to appear. Everyone knew what was going on, and they did so with the intent to change the outcome of the trial. That could be a big deal.
Melissa, is that possible that someone's grandfather could have gotten a summons, which it seems like is the implication here? It's hard to make what it could be of a 1945 birth date versus 1970. It doesn't sound like the person accidentally put down a birth date, but rather the jury panel, the county's record had 1945, but this person looked much younger. Is that even a possibility, or would that not be something that the court would verify before going forward?
I think it would be possible. That's the same thing Eric mentioned is what I immediately thought of as a son or father and son with the same name. Maybe one is a junior. I can say that sometimes juniors don't always use junior, and they just use their name and get their father's mail or respond to it. So that's immediately the situation that came to my mind, is that the son responded to the father's summons and was the person who went to court. I would think that once he got to court, the jury clerk would verify his identity, to generally check IDs. Apparently that wasn't done in this case, to verify that it was the right person that responded. But I think the judge is going to look at the impact on the trial, or whether or not Ms. Heard was prejudiced in any way in order to warrant a new trial. As opposed to some type of instruction to the jury to hopefully make sure that this doesn't happen again.
I do want to follow up with you, Melissa. Do you think that would be a huge problem if someone is lying about being on this jury panel? Would that change this verdict? I mean, they were a person, they sat and they listened to all of this evidence, but what's going to be the argument? Do you think that could be grounds for even an appeal?
Definitely a ground for an appeal. I don't know if it will be a successful ground for appeal, because if this is the same person who was in court, who was questioned by both parties, so if this is the person that they believe to be on the jury, it was just the wrong person who was sent the summons, I think that's a clerical error that wouldn't necessarily warrant a new trial. If this is just some random person who, after all of that, took the place of the proper person, the person who had sat in court and been questioned by the jury. And we don't know who this person was. I think that's a completely different situation.
I want to read a little bit more of this court filing. It's very long. It has a lot of allegations when it comes to this verdict not being consistent with law. But more to the point of this juror, it says to the extent that the individual who served as juror 15 was not, in fact, the same individual on the venire. And that just means that this is the jury panel of prospective jurors, or that the court's clerk office didn't verify his identity, Ms. Heard's due process was compromised. This is an additional attempt. We've seen several, and we've heard from Amber Heard's team that they plan to get this appealed, but this is their first level that they have to go to. They have to go back to the initial trial court asking for a new trial, but all of this they're putting on the record. But I have a question for you, Dr. De Silva, just about the larger picture of this. This was a case that was very heavily rooted in dueling psychiatric experts that testified about not only what Johnny Depp went through, but Amber Heard. And this really has been a case that's not just in a court of law, but a court of public opinion. When you look at this case, what has been your reaction to the impact it has had when it comes to the public and how they may view it if this verdict gets thrown out?
Well, when I look at this case, I think about all the feelings that are there. They're so intense, both on Amber Heard's side and Johnny Depp's side, and then the feelings that people watching them, that it evoked for people. I mean, it was passionate, but dysfunctionally passionate. I think that watching them and seeing how they reacted to each other really drove home the point that we all have these very vulnerable feelings, and then we don't necessarily know how to deal with them. And so we deal with them in these quite maladaptive ways. And I think that the trial really brought that out and saw like the impact that these defenses and these ways that we manage our disappointment and our fears and our love and our passion for each other and our betrayal feelings, and then also the substance use and the lifestyle and all these complicated factors that impacted their relationship just was aired for all of us to see. And I think that everybody could kind of relate to these very volatile situations between the two of them. So that's really what I took from the case, was that it was a lot of almost like dirty laundry being aired, but it's everybody's dirty laundry that we all deal with in a pretty extreme way.
I really appreciate getting your insight on this because, of course, we watched it play by play here on Court TV. Passion is, I agree with you, that is the word that I felt from the public in watching this and really being seemingly connected to these people. I want to talk just a little bit more, Eric, asking you about this particular argument by the defense for Amber Heard. How do you think they even figured this out? And should they have figured it out earlier? They said that public records show that this person was born in 1970, but it doesn't seem that they had this information beforehand.
And that is an interesting question. Usually you think during jury selection, you talk to the jurors, you at least look at them, you identify the individual who you're looking at, the prospective juror, and the information that you're provided by the court. And I do think that discrepancy of decades should kind of jump out at an attorney during jury selection. And that would be true if it's one attorney doing the selection. But usually in cases like this, when you have such high stakes and so many people involved on each side's legal team, you might have someone there just for that very purpose, to look at the prospective jurors, look at the information that's provided by the court, look for any sort of discrepancy. So it is surprising in a way that it's just now being brought up. But it's not surprising, I guess, in one sense, that after an unfavorable verdict, that motion for a new trial or motion to reconsider, usually it's a kitchen sink type motion. You throw everything you can at it, and this is one of the things they've come up with. It's one of the more interesting ones. It seems to have a lot more a lot more merit to it than just the general idea that the jury got it wrong. Courts, generally respect the jury's verdict. So it'll be interesting to see how it plays out.
It seems that often in these very high-profile cases that the request for an appeal has to do with problematic jurors. That just seems to be what we're seeing more and more in many cases. But you raise a good point, Eric, that they often have jury experts sitting there in the courtroom watching these jurors doing voir dire. So in this case, it seems like that was something that was missed. Thank you all for your insight.